It's not like people are just now stepping up and saying, let's help them out, right? I mean, they've been there the whole time. And here we are with our fifth felony. Ms. Reyes, you are Angela Reyes, correct?
Yes, ma'am.
And Ms. Reyes, in cause number 26, DCCR 0265, you're charged with the third-degree felony offense of obstruction or retaliation from December 22nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 26, DCCR 0787, you're charged with a second-degree felony offense of assault on a peace officer. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0788, you're charged with a third-degree felony offense of harassment of a public servant. And that's from March 17th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like the agreements that you've reached in these three cases would be for you to receive 10-year deferred probations in each case. There would be fines in each case of $1,000. You would be ordered to.
Your Honor, I'm sorry. I don't know that it was the intent of the state to have a total $3,000 fine. I'd be willing to waive the fine on 2 of those cases and just have.
So a $1,000 fine in, let's just put it in 0265.
Yes.
And there would be no fine in 0787 and 0788. Is that your understanding?
Yes, ma'am.
Is it also your understanding that you would submit to a mental health evaluation and follow any and all recommendations and treatment, be on that mental health caseload at the probation department?
Absolutely.
State tenders number 1 in each case.
No objection, Judge.
It's admitted in each case. Is there any evidence that Ms. Reyes is not competent?
No objection.
Right, ma'am. In each of these cases, and also part of the agreement is that the state would dismiss all of the other remaining cases. Is that your understanding?
Yes, ma'am.
Released on probation when we come back for sentencing.
Okay.
Okay, you can go back with the bailiff.
Thank you, Judge.
Thanks, sir.
Right, are you Jameldrin?
Yes.
Willridge? So we're here. Mr. Willridge has he's on probation in 3 cases, 18-28743, 28744, and 30139. And then there's a new offense of burglary of a habitation in cause number 25, DCCR 1804. And there was an agreement that was reached, and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between, obviously, when he pled and now, which required I revoked that bond because he was arrested on May 26th in Chambers County for a third-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay, so where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason, if those allegations are true, that Mr. Willridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in, without permission, and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last month, it was primarily, obviously not knowing that was gonna happen in Chambers County for the restitution in the burglary. Because we
Right.
all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Willridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
And Judge, only thing I can say in that regard is that, of course, I've dealt with him for a long time in this situation, and he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when the whole bond situation occurred. But of course, he turned himself in, did what he's, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
no,
think
it
he has
doesn't.
that.
And I guess, you guys know, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed. And
The only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
And that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out. Right. They've been there the whole time. And here we are with our 5th felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can, so that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I would see, I guess, where if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously, probation, I value your opinion, and so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a compliment.
It's needed to talk now, so that's good.
okay. All right, sir, are you Hector Wiggins Jr.?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Your Honor.
Mr. Wiggins, in clause number 24, DCCR 0548, you're charged with a state jail felony offense of theft of property with previous convictions, and that's from November 4th of 2023. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily,
Yes, ma'am.
and because you did what they charged you with?
Yes, ma'am.
Your indictment also alleges you were previously convicted of theft, July 14th of 2022 in Montgomery County, Texas, 2 cases on that day, September 9th of 2022 in Montgomery County, February 27th of 2023 in Harris County, and 2 cases on that date in Harris County. And are all those prior convictions true?
Yes, ma'am.
Did you enter your plea of true also to those freely and voluntarily?
Yes, ma'am.
And because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So what is the, what are those latest? The 22 and 23 cases, punishments on those?
Got, here, I've got something for you, Judge. I just seen it.
He's on Habitual now.
That's what I figured just based on the counties. Thank you. Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Wiggins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of property with previous convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so, Mr. Wiggins, you've done a whole lot in the last few years with regard to thefts. And I want to make sure you understand that if you're back in Jefferson County and you commit a theft again, it's not going to go this well. You now have enough prior cases to where you probably could be enhanced potentially to a 3rd-degree felony and go to TDC for up to 10 years. So you're okay this time. You got your deal. I went along with it. But if you continue to do that, it's just going to get worse and worse every single time. Do you understand?
Yes, ma'am.
All right, and go back with the bailiff.